And I call on Stuart McMillan to speak on behalf of the Delegated Powers and Law Reform Committee for around 7 minutes. Mr McMillan.
Thank you very much, Presiding Officer. First of all, I am delighted to open this debate on the Delegated Powers and Law Reform Committee's inquiry into the use of the made affirmative procedure during the coronavirus pandemic. At the outset, I would like to thank all those that appeared before the committee and provided written evidence at very short notice. We only agreed to hold the inquiry in late November, so we are very grateful to hear from so many in such a short space of time. I also want to thank the Clarkin team and also the legal team who have been invaluable during this inquiry and have ensured that our report was turned around in such a short time frame that we allocated ourselves. Being able to hear from witnesses remotely allowed us to take evidence despite new restrictions due to the Omicron variant. While I know meeting in person is always preferable and beneficial, virtual meetings have their place, and they can sometimes be challenging, as we know, Presiding Officer, but they provide Parliament with another option to hear from witnesses, in addition to helping reduce the carbon footprint of Parliament and also individuals. Before I cover the committee's main findings, I want to first mention why this work was important and should matter to us all here in Parliament, and also not just to the 5 members of the committee. The use of the made affirmative procedure since March 2020, which has allowed the Scottish Government to bring into force a large number of very significant powers immediately, is a classic case of a debate which predates us here in the Scottish Parliament, namely the balance of power between Parliament and also the Government of the day. Dr Ruth Fox, Director of the Hansard Society, reminded the committee that debates on how statutory instruments are laid and scrutinised were taking place in the 1930s. Books were published in the aftermath of the Second World War about the government by diktat and the use of emergency provisions. Dr Fox told us that concerns about the concentration of legislative power with the executive and the shift of influence away from Parliament has been, and I quote, a long-running sore. So the committee's report should be read in the context of that history. The committee is clear in the report that we do not wish to remove the made affirmative procedure. The committee has regularly acknowledged that the made affirmative instruments have allowed the Scottish Government to respond quickly to the many challenges presented by the coronavirus. However, we do want to ensure that bringing such substantial changes into force immediately, changes that have often impacted on all aspects of our lives, before any parliamentary scrutiny should only be used if essential, and such emergency powers should not, as we have often heard from witnesses, become a habit. We want to make sure that the balance of power between the Parliament and the Government is indeed balanced. Each of the committee's recommendations have sought to do just that. Our first set of recommendations focus on the clarity and accessibility of law. We heard from Sir Jonathan Jones QC, the former head of the UK Government's Legal Department, that within the Westminster context, there were times during the pandemic when extreme urgency was prioritised over the quality and comprehension of legislation. The Law Society of Scotland highlighted concerns about the clarity and accessibility of made affirmative instruments, which are subject to frequent and significant amendment. It suggested that when amending an instrument, the Government should produce a consolidated version showing the whole instrument as amended. And the committee agrees. We want to ensure that all legislation is properly and clearly drafted, so that it is legally accurate. It should also be easy to find and also can be interpreted by all, particularly given that many regulations made during the pandemic placed significant restrictions and potential criminal sanctions on individuals and businesses. Our various practical recommendations seek to help this to happen. The report then calls for a number of changes to how made affirmative instruments are brought forward. Currently, the majority of made affirmative instruments are laid under the 2020 Coronavirus Act and the 2008 Public Health Scotland Act. Under both acts, it is for the Scottish Government to determine whether the regulations need to be made urgently. The University of Birmingham's COVID-19 Review Observatory found that the frequent use of the made affirmative procedure since the start of the pandemic raised questions about how the urgency threshold is operating as a constraint. Others spoke of the potential for the made affirmative to become a habit. The Deputy First Minister told us in committee that the use of the procedure is not the default view of the Scottish Government. He also said that he would consider adding a statement of urgency to all made affirmatives. The committee has called on the Scottish Government to do just that. If the committee is not satisfied with the Government's justification, it reserves the right to seek to raise this matter in the Chamber and to do so quickly. The committee has suggested options for how this might work in practice during using current procedures. It has also invited the Standards, Procedures and Public Appointments Committee to explore further procedural options as part of its inquiry into shaping parliamentary procedures and practices for the future. The committee would be very grateful for the SPPA committee to consider this as part of their work. I'll move on, Presiding Officer, to how the Parliament looks at the proposals for made affirmative powers in new bills. This is already very prescient. The committee had an initial look at such proposals in the Coronavirus Recovery and Reform Scotland Bill this morning. And Professor Stephen Tierney, the Professor of Constitutional Theory at the University of Edinburgh, told the committee that adequate scrutiny of primary legislation, which creates delegated powers, is a key part of robust lawmaking. The committee agrees. To ensure this robust approach, we have outlined a set of 4 key principles that we'll use to scrutinise any such proposals. And go back to my opening comments, we hope that these will help to ensure that there is an appropriate balance of power between the Parliament and also the Government of the day. Finally, Presiding Officer, let me briefly highlight the expedited affirmative procedure. The affirmative procedure enables the Delegated Powers and Law Reform Committee and the lead committee to conduct their respective technical and policy scrutiny roles before proposed changes are made into law. And as Morag Ross QC, representing the Faculty of Advocates, noted that individuals might scrutinise legislation already in force differently from legislation which is still prospective. The committee would therefore be happy to consider with the Scottish Government, the COVID-19 Recovery Committee and the Parliamentary Bureau on a case-by-case basis for when the use of an expedited affirmative procedure as an alternative to the use of the made affirmative procedure might be appropriate and the parliamentary timescales for such scrutiny. Presiding Officer, in conclusion, I refer members to sections 106 and 107 of the committee report. And we acknowledge that the Scottish Government did not start out in 2020 with a plan to use the made affirmative 146 times. However, we did embark on this short inquiry because of the importance of proper parliamentary scrutiny that leads to good law which is accessible to all. And with that, Presiding Officer, thank you very much and look forward to hearing the rest of the contributions in the debate. Thank you.
Thank you.